All right, this is Roger Roots with a little bit of a report about some court cases that are sort of on the sidelight of the criminal case. Of course, we're all watching the big criminal trial that's underway right now. United States versus Cliven Bundy, Ryan Bundy, Ammon Bundy, Ryan Payne. Huge trial, probably the biggest trial in the country. But I wanted to just alert the viewers to some side cases that I've been working on. Of course, I am admitted to the bar of the U.S. Ninth Circuit Court of Appeals in San Francisco, which is over the U.S. district courts of a lot of the western states, including Nevada. I have taken on a case for Cliven Bundy. Cliven Bundy had two cases, civil cases, way back. He litigated a case that started in about 1998. That case went on and on and on for years. There were a couple court orders early on in about 1999 ordering Cliven to get his cows off the range up there. Anyway, and then that court order just sat there for 10 or 11 or 12 years without any execution or implementation of any kind. By any test of finality, that case died. But somehow the government, in about the year 2011-ish, launched it or started filing more things in that case. Don't ask me how they got away with that. The government also, in about 2011 or 12-ish, filed another civil case against Cliven Bundy, alleging that some of his cows were on what they called new trespass lands, which they claimed were the Lake Mead National Recreational Area lands, which is a little bit south from the Bundy Ranch, primary area. All right. Anyway, those civil cases they both died in 2013, with judges issuing summary judgment for the government against Cliven Bundy. Okay, those were the court orders that led to the big what would you call it? The big incident in April 12th of 2014. Okay, it was those court orders where they were, they claimed they were executing court orders to impound cattle. Of course, the BLM did a lot more than that. Anyway, to make a long story short, one of the cases died in 2012 or 13, and with that summary judgment ruling by the U.S. District Court of Nevada. Another one, the new trespass case, Cliven was pro se at that time. Cliven did a very good job of litigating back then. He really litigated very, very well for 20 years. But he was up against all the combined powers and forces of the U.S. government. And but he did file a notice of appeal in one of the cases up to the U.S. Ninth Circuit. And then he did not follow through and file a brief in that case. The clerk of the Ninth Circuit in about the year 2013 summarily dismissed his appeal back then. Okay, that was 3 years ago. Anyway, I have taken on both of these cases now. Mr. Cliven Bundy has entrusted me to see if I can revive these cases. And it's a little bit of an uphill battle, of course, because federal courts like finality. They don't like to revive cases. Keep in mind, they did it for the government after the government had a dead case for 10 years. So anyway, in any case, I've entered my appearance in United States versus Cliven Bundy in the Ninth Circuit, the one in which there was never a brief filed. I have filed a motion to recall the mandate on the grounds of, well, several grounds. Number one, there was a lot of confusion at the time, especially with regard to the two separate court cases simultaneously going against Cliven Bundy at that time. Also, just with regard to the merits, we've increasingly found that the government lied on some of its assertions in the new trespass case. And a shout out to my friend Rand Cadmus, who discovered that the government actually asserted some GPS coordinates, claiming falsely that the cattle, some of Cliven Bundy's cattle were found in the Lake Mead National Recreational Area. And they gave the district court in that case GPS coordinates that my friend Rand Cadmus checked out, and in fact those GPS coordinates pertain to the Bunkerville allotment, not the so-called new trespass grounds, the National Park Service, National Lake Mead Recreational Area. Anyway, so they're just some false statements that the government used back in 2013 to get summary judgment in that case. Again, we're trying to revive that in the Ninth Circuit. If my motion is approved, we will be filing a brief and continuing that litigation. Okay, just today being November, 15th, 14th?
14.
Myself and a Nevada lawyer by the name of Robert Kurth, very good man. I finally found a great Nevada lawyer, Robert Kurth. He has filed a motion to get me admitted pro hac vice in the other civil case. The two of us have filed a 60B motion to reopen, set aside, and vacate the other civil case. So we're trying to revive both civil cases now. Several grounds. There's a lot of estoppel issues. Also, the government made a big showing in 2014 of trying to execute this order, but the mere fact that the government did so many things, the BLM did so many things that were outside the order, makes me believe, and I think the plain order shows that it's void. It's just simply void for vagueness, because if the BLM can't even figure out what it means, and they took an order that authorized them to impound cattle, and instead they were out roaming the landscape, tearing up infrastructure, setting up First Amendment zones, closing off 600,000 acres of land to the public, which was not even mentioned in the court order. Anyway, if the BLM can't decipher a court order, then it's void for vagueness. Several other grounds. Anyway, just I'm going to try to get these both cases revived, and we will keep you posted.